Well, good afternoon, everybody, and also welcome to those of you who are online listening. Recently, we've seen a number of violent incidents against law enforcement, and it is, to say the least, troubling. Within 1 week, there were 7 officer-involved shootings statewide. Tragically, a shootout in Flagstaff led to the deaths of a DPS pilot and a trooper paramedic when their helicopter crashed. In Maricopa County, in 1 week this month, we had 4 shootings involving police, and 3 of those were within hours of each other. In one of those shootings, a DPS trooper was shot and 3 others were hurt by shrapnel. In 2 incidents, the suspect either fired a shot or pointed a gun at law enforcement. Before I continue, let me remind everyone that the comments made are not evidence. Everyone is innocent until proven guilty in a court of law. But today I am announcing indictments in 3 of these cases, all of which happened on the same day. The first is Darrell Bell, that's D-A-R-R-E-L-L-E. Bell is common spelling. Mr. Bell is charged with 21 counts of aggravated assault, 1 count of unlawful discharge of a firearm, and 3 counts of misconduct involving weapons. On February 5th, the DPS SWAT team went to serve an arrest warrant on Bell when he opened fire as they moved in. About an hour and a half earlier, members of the Phoenix Police Fugitive Apprehension Unit were trying to serve a warrant tied to a homicide investigation when Valerie Corona pulled a gun on officers. Before this happened, she had made comments that she would shoot if police tried to contact her. Corona is charged with 2 counts of aggravated assault. Later that same night in Chandler, 2 officers noticed a truck with a license plate that did not match. When they stopped the truck, Gabriel Leone took off running, firing a shot into the air while doing so. The chase continued for a few blocks before it ended with an officer-involved shooting. Leone is indicted on 1 count of aggravated assault, unlawful discharge of a firearm, and misconduct involving weapons. Most recently, a Goodyear officer suffered a graze wound during a struggle for his service weapon with a suspect. Every time an officer is attacked, ambushed, or threatened, we all lose. We lose good people who might have continued serving. We lose the foundation of a civil society that follows the rule of law, and our communities suffer from it. The overwhelming majority of officers are doing an impossible job the best they can. They are running toward danger while everyone else runs away. They're dealing with our worst days, our messiest problems, and our darkest moments. And yes, we should hold them to high standards, but we should also have their backs when they're doing the right thing. Because at the end of the day, these officers are a part of our communities. They coach our kids' sports teams, they shop at our grocery stores, and they deserve to go home safely to their families. Now, related to this, I want to talk to you about bond amounts, because in one of these cases, I was very troubled at the bond that was set. In the Phoenix police case involving Valerie Corona, we asked the court to set her bond at $1 million cash. This was an appropriate amount given the gravity of the allegations against her and the threat to the community. Instead, a commissioner set her bond at $25,000 secured. As many of you know, a secured bond typically means someone needs to post 10% to be released. So we're talking about $2,500 for her to get out of jail after pulling a gun on police. One of my priorities as county attorney has been to fight for meaningful bond amounts, especially in cases involving repeat offenders, violence, and weapons. Too often people are arrested and released before the officer who took them to jail finishes his shift. And we've got to stop this revolving door. We cannot continue to allow dangerous individuals to cycle in and out of custody while awaiting trial, leaving them free to reoffend, tamper with witnesses and victims, flee the jurisdiction, and place the public at risk. So when you're frustrated after seeing the news that someone who is dangerous or a repeat offender get out on a low bond or be released on their own recognizance, let me just say this, I get it. it frustrates me too. My team is pushing hard to make more judges and commissioners aware of what's at stake when they do not follow our recommendations for appropriate bonds. And we're going to keep fighting for bonds that protect the community and put public safety first. Now, while we're talking about police shootings, I know many of you have questions about the incident involving Phoenix police last month where Christian Diaz-Rendon was killed by an officer. Here is the status. DPS is conducting its investigation into the shooting, and when they finish, they will submit it to my office. Because they have not submitted it, I have not reviewed it, nor have I made a decision. Once they have completed the investigation, senior prosecutors in the office and I will carefully review it and consider all of the evidence, and I will explain my decision, whatever it is, at the time it is made. Now, with that, I'm ready to answer your questions.
Hello.
Hi.
I have a question regarding the child abuse case out of Glendale that we learned about earlier this month. We know that your office has requested more evidence in this case. When officers are documenting the living conditions and the walls and floors covered with feces, a firearm within reach of two extremely young children, what additional evidence is your office looking for in a case like this?
Without addressing that case specifically, since it's an ongoing investigation, let me talk generically. There are multiple levels of child abuse in this state. There is a child abuse where it is a Class 2 dangerous crime against children if the child is put in danger of losing its life or suffering serious physical injury. That's a Class 2 dangerous crime against children. There is a lesser offense of child abuse when it's other than circumstances likely to cause death or serious physical injury. That's a Class 4. There are times when we need additional evidence to shore up if there is a more serious, or at least explore whether there is a more serious charge. What we don't want to do in the meantime is to charge the lesser offense, if that's what we have evidence of, which would allow the suspect or defendant to go into court, plead to that lesser offense, thereby, because of double jeopardy, precluding us from filing the greater offense. So while it can be frustrating to wait, it is the legally sound, strategically sound thing to do.
A follow-up question to that. Do you believe that perhaps waiting for physical injury or evidence of physical injury, are we putting children in danger by waiting for someone to get physically hurt?
You know, fortunately, we are, not only have the police looking at this, but you also have Department of Child Safety looking at this. And so they're, governing what children these people can come into contact with. And so it's nice to have that partnership.
A question about an unrelated case.
Okay.
We have seen an increase in road rage cases. There was one that happened on the corner by our station on 7th Avenue in Missouri. In that case, a man spit on a woman. That woman pulled a gun, ended up shooting and killing that man. Are there any charges that are coming in that case specifically?
So actually, at the last press conference, we talked about that had just come in, I think, to the office. Since that last press conference, we have reviewed it at senior levels. I have personally reviewed that case. The consensus was, including my belief, was that we needed an additional piece of evidence. Because this is an ongoing investigation, I'm not going to name what that piece of evidence is, but I think it's important. And once we get that, we will make a final decision.
One more question for you.
Okay.
When it comes to a bill that your office had worked with Julie Earfley on and Representative Wynn, we learned that bill is now a striker, essentially killing it for this legislative session. That was a bill that had a lot of overwhelming support, bipartisan backing. What's your stance on a bill like that had a lot of Republican support, prosecutors' support, and even support from gun rights groups and police groups being killed by a Republican representative.
Well, for those watching who may not be familiar with that bill, Julie Erfle is the widow of a Phoenix police officer who was killed in the line of duty. And under state law requires that that gun be released back into the stream of commerce by being sold. Julie Erfle has understandably asked that the gun that killed her husband be destroyed, and I have, from several months now, told her that I would stand shoulder to shoulder with her. You know, it's disappointing that people see this as a Second Amendment issue. I am a big supporter of Second Amendment rights, and I would challenge anybody to be a bigger supporter. But this is not about the Second Amendment. This is about common sense. This is a widow who doesn't want the gun that killed her husband to be resold. And just as it can be used as a striker, it can also be used to strike another bill. And so I'm still hopeful that this legislation passes. It's common sense. It is not a step down the slippery slope of destroying guns. It is just the human thing to do.
I think the interesting part of that is that Representative Wynn is also the chairman of the Arizona Citizen Defense League. For him to strike down his own bill, have you heard of a reason as to why that happened?
I haven't talked to him specifically about that, but, like I said, I still see, as you have said, that there's overwhelming support for this. This is just humanity to do this bill. And I still hold out hope that we can pass it through other means, including the strike-all amendment.
Thank you.
County Attorney, how are you?
Good, how are you?
Good. I had a question about the bond amount that you put up there on the screen. In your career as a prosecutor, have you seen a disparity that large before in terms of what prosecutors request versus what a commissioner or a judge or magistrate sets? Have you seen one that large?
I can't say that I haven't seen one that large. I've seen large disparities. This one certainly sticks out to me as concerning.
Is there anything your office can do? Can you have direct conversations with that commissioner and say, hey, this is particularly upsetting to me in my office, and express public safety concerns to that person?
Well, let me answer that in two ways. Number one, my office does staff the initial appearance court where bonds are set 24/7. So there was a conversation with the commissioner. Beyond that, I can make my feelings known to the court, and I have done that in this case.
Okay. I had a question about a sexual assault case we've been following closely. This is a case where a husband has been indicted on 8 felonies, accused of drugging his wife using various sedatives, and then allowing men to come into their home or various Airbnbs and sexually assault her themselves. Mm-hmm. As a sex crime prosecutor yourself, how do you feel about this case? Does anything stick out to you? And it feels as though when you read this Form 4 that this is one of the worst ones I've personally read. And I'm wondering just the impact to this victim, too, if you have any thoughts on that as well.
You know, unfortunately, most sex offenses are committed against victims by people they know, and a large number of those actually, are committed by somebody that they trust. I know that when a victim is violated by a stranger, it's traumatic. When a victim is violated by somebody they trust, especially somebody as close as a spouse, the trauma goes through the roof. So, yes, it's incredibly disturbing. That's, I believe we have him indicted for 7 counts of sexual assault.
Mm-hmm. 2 more questions from our newsroom, if I can. Last week, Attorney General Mace said her office and yours were conducting an investigation into Governor Hobbs' relating activities to Sunshine Residential Homes, a group home provided for foster care. Is there an update on that case that you can provide for the public?
Yeah, I received a briefing from the Auditor General not that long ago. They have not yet completed their investigation. We gave them some additional areas that we wanted explored. To be clear, it's not a joint investigation with the AG's office. We're separately conducting investigations. We did do one joint interview for, efficiency's sake, but I am tracking that as the investigation goes on by the Auditor General.
Okay. When do you see that concluding? Do you foresee that?
I think they are understanding that there is, a desire to have that done as quickly as possible. But as I've stood up here and said about many investigations, I'd rather have it done well than have it done quickly. That said, I know that there is an urgency to it. They know that too.
One more for you. State Superintendent Tom Horn has told 12 News that he's been referring ESA cases to your office when he finds misspending. Have you prosecuted any of those cases to date, and is there an update on that you can provide?
I know that we've reviewed some. I don't want to state exactly what stage they are in the process, if they're filed or concluded or whatever, but my team can certainly get you that information.
Great.
But
Thank
I
you.
know we have definitely had referrals that we have done further investigation on.
Okay, thank you.
Hey.
Hi, just one question on the bond issue. Would you be advocating for or trying to work on any state legislation to move the needle on that issue?
I would support legislation looking at certain things. I know that actually, there was a voter initiative that was passed by, I think, 80% of the vote back in 2000 or 2001 regarding sex crimes, and it was struck down by a higher court. So, we have to make sure that that's not going to happen again. But, really, this is a common sense kind of thing. And so I would say we should be guided by common sense and not need legislation for that.
Thank you.
Yeah, back to that bond issue. When you say common sense, what are you saying? There's a gap between what your office estimates as far as risk and what the commissioners are estimating?
I can't get into what the commissioner's thought process was. What I can tell you is that when I'm looking at what an appropriate bond is, one thing I know is the best predictor of future behavior is past behavior. So I'm looking at the current offense, I'm looking at the past offense, I'm looking at the seriousness of the charges, how much time they're facing, which could, of course, incentivize somebody to flee. I'm looking at past failures to appear. I'm looking at a whole plethora of things to decide what an appropriate bond is.
So why do you think this gap exists?
I can't answer that. Obviously, we're not trying to recommend high bonds. We're trying to recommend appropriate bonds.
Okay.